Roger, what are you doing on this call? You could teach this thing. I could just go back to my office and let you take it from here.
Trying to learn something every day. I think there's some pretty good topics.
Yeah, this is a good topic. Do we need anything, Lucy, to get started, or you'll just cut that part out?
No, we can cut that out. It's already recording, so
Oh, we're
good
already
to go.
on?
Yeah.
Okay, Natalia, we're already recording. Be
What's
careful.
up?
Okay.
I gotta watch my mouth.
Okay.
But I think by the looks of it, that's.
Thanks, Cal. You can listen too if you want. You might learn something. Okay. Good afternoon, everybody. We're here to talk about entity selection and formation and asset protection. I get this question all the time from clients that want to form a new company. They say, do I want to be an LLC or a subchapter S corporation? And the way I explain it is they're really cousins. They're very, very similar. And the way, so over here, this is LLC world and this is corporate world. And everybody knows that a corporation, a subchapter S corporation, is the same as any other corporation. It's the same as Google or Microsoft or IBM. It's just that you make an election under subchapter S of the Internal Revenue Code to be taxed as a pass-through entity. You guys understand that? You know that? So to be taxed, so when you're a corporation and you do this S election, you become a pass-through entity like an LLC. Now, corporations are kind of clunky, and you're going to see as we go through this, they have some requirements that make it difficult for small business to conduct business. And so the legislature, in their wisdom about 30 years ago, created something called an LLC that tried to simplify things, and they have simplified things to a great degree, but there's still some pitfalls that I warn clients about all the time that have to do with governance. But anyway, so we form an LLC with a certificate of organization. That's the functional equivalent in the corporate world of articles of incorporation. All right? Then, so that forms the entity. In the Pennsylvania Business Corporations Act requires that you have bylaws. The functional equivalent of bylaws in LLC world is an operating agreement. Sometimes, well, in corporate world, they're called shareholders. And in LLC world, owners are called members. Now I'll tell you that I think Delaware's statute calls them stockholders. And so to be hyper technically legal, or I could have them mixed up. We could be stockholders and they could be shareholders. Anyway, somebody fact check me on that. But when you're talking about forming a Delaware corporation, know there's a difference and talk about the difference. And then there's something that people refer to in business as a buy-sell agreement. A buy-sell agreement is a vernacular term that I really hate because it really doesn't capture the essence of what it's attempting to do. But a buy-sell agreement is a shareholders agreement. All right, so a shareholders agreement is, and the functional equivalent in LLC land is a members agreement. A shareholders agreement and a members agreement is a document that controls the relationship vis-a-vis the owners upon the occurrence of a triggering event. What's a triggering event? Death, disability, divorce, bankruptcy, retirement, voluntary quit. And so, why is that important? Well, when you own stock in Google, it's probably not so important, right? Because when one of those events happen, you can bequeath your stock to anybody you want. You can sell your stock on the public exchange. But in small business, when everybody's sort of thrown in together and we're all going into business together, we're all going to contribute to the enterprise, it's kind of important that everybody participates and contributes. If Jake and I were going to go into business together and we were going to be working hand in hand, and let's say I roll a 7, then is it okay for Jake to be partners with my wife? That's probably not okay. So what happens is that's a triggering event, and it triggers a buyout. And so Jake, or the LLC, or the corporation, buys out my stock, so my estate has cash, has liquidity, and Jake now owns the whole business. Same thing with disability. What about disability? If I'm disabled for a month or 2 or 3 or 6, that's probably okay. But what I tell clients is, given the level of medical advancement and technology in today's world, if you're not back to work by 12 months, you're probably not coming back to work. And so, but you could pick any time you want. You could pick 6 months, you could pick 18 months, it doesn't matter. But you got to draw a line in the sand and you say, look, if you're not back to work, you're disabled, and you're not back to work by this certain time period, that triggers the buyout. So instead of me convalescing at home, or being completely or permanently disabled, collecting profits from the enterprise that Jake and I started, that's going to cause resentment for him. He's going to hate sending those checks to my house because I'm not contributing. I'm not carrying my weight. He's doing all the work, and I get half the profit. How's that fair? So it triggers a buyout when there's a disability. Divorce and bankruptcy, same kind of thing. But in this sense, when there's a divorce, then the family law judge can order equitable distribution. And if part of my estate, part of what I own personally, is stock in this enterprise that Jake and I are working on together, then if I don't sell it, if Jake doesn't buy it, and I get cash to deal with my spouse, then that stock is subject to equitable distribution by the court, and then Jake, if the court does that, then Jake is partners with my spouse and me, and that's probably not okay. And frankly, I wouldn't want to be partners with an ex-spouse either, right? So what does it do? It triggers a buyout. I have cash, I have liquidity to buy out my spouse. Bankruptcy is the same way. When there's a bankruptcy, the trustee in bankruptcy has control over all your assets, and they can sell those assets to anybody they want. And they're trying to get liquidity to pay off your creditors. Well, Jake's like, hey Dan, I don't want the trustee in bankruptcy to sell the stock in our company to Joe Schmo. I'm going to buy you out. So, divorce, bankruptcy, retirement or voluntary quit. What happens if I say, hey Jake, I want to retire. We've been working at this for 15 years. I'm way older than you. It's time for me to set back. Well, is that okay? Same thing. Is that okay for me to sit at home and collect profits? Or does that trigger a retirement because Jake needs somebody in the business to do the job that I was doing? So typically retirement triggers a buyout. Same thing with voluntary quit. How about this one? Jake walks into my office some morning and says, Dan, I've had it. Throws his keys on the table and says, I'm out. I'm going to Tahiti to start a surf shop. And send me my profits. Send me my share of the profits. I'm like, Jake, that's not cool. That's not fair. So what do? We write into the members agreement that when there's a voluntary quit, that triggers a buyout, because it's not okay for Jake to be laying out on the beach somewhere and me sending him beer and pizza money. So what do I call this thing? I call this thing a shareholders agreement in In LLC world, it's a members agreement because technically that's the name of the owner. And the way I put it to clients is always write the divorce agreement while you're still in love. I'll say it again for those of you that are taking notes. This is very important. Always write the divorce agreement while you're still in love. And the point there is, if you ever refer to this agreement, you got a problem. If you're able to conduct business and run the enterprise without ever referring to the divorce agreement, then you know you're doing things right. Okay, so that's a little primer.
Quick question.
Yeah, sure. We take questions.
Divorce agreement, you mean as a divorce of the company, correct?
Yes, the divorce between the owners.
Gotcha.
Okay. Back to forming a corporation or an LLC. And so a lot of business owners or two people that come in and say, Dan, we want to form this company together, this isn't required. They don't necessarily have to have it, but I strongly encourage it. They also always say, hey, we want to be 50-50. There are only two. Or three, a third, and a third. That's not so bad, but when there are two and they want to be 50-50, you have to recommend against it. You have to advise them that it's really important to not have a stalemate and have someone be 51 and somebody be 49. Well, when we're forming these companies, we do introductory meeting minutes. And we do the same thing over here. And these, and all these documents are, if you don't already know this, they're all stored in a corporate minute book. And if you don't know what a corporate minute book is, stop down into the library and you'll see 1,000 of them. So hyper-technically, legally, when you form a corporation or you form an LLC, the organizer has one job to do. So me as the organizer, I really have one job to do, and that is to transfer ownership to the people that hired me to form it. And so in the introductory meeting minutes, it's the very first order of business is me as organizer transferring ownership to my clients in the percentages that they've identified. If and then after the organizer does that act, then the introductory meeting minutes are minutes that the owners, the stockholders or the members, perform in order to be able to open a bank account, file the minutes, authorize the formation of the company, and there's a list in our standard introductory meeting minutes that that is pretty straightforward, and when you read them for the first time, it'll make a lot of sense to you. So another aspect of corporate law is the Pennsylvania Business Corporations Act requires that you have a president, a secretary, and a treasurer. Must have. In LLC world, you don't have to. But let me tell you something. Whenever a business owner who's an LLC member goes to sign a contract or open a bank account, the person on the other side of the counter says, okay, who's the president? And the answer is, well, we don't have a president. We're an LLC. Oh, yeah, you have to have a president. Every company has a president. No, we're an LLC. We're members. What's a member? I never heard of a member. Right? That's what you're going to get from the public because they're not lawyers and they haven't studied these acts of the legislature. And so what we do to make it easy on the business owner is in LLC, if we're forming an LLC, in our minutes, we do a resolution to appoint a president and a secretary and a treasurer. Okay, moving right along. in the corporate world, you're required to have the shareholders must meet by statute once a year. So, shareholders get together once a year. They have one job. What's the job of the shareholders? Who knows? That's right. Whoever said that. The shareholders appoint the board of directors. And you set in your bylaws how many directors you have. I don't want to go into that level of detail here. But the shareholders elect the board, and then the board is required by statute to meet once a year and do at least one thing. Who knows what that is?
Like the office.
That's right. They elect the officers. So, shareholders appoints the board, and a board, if you don't know this, helps give direction and guide a company. They must meet at least once a year. Sometimes they meet every quarter, sometimes they meet once a month. That's a little unusual, but they give guidance to the officers who are doing what? Running the day-to-day business. So, those meeting minutes go in your corporate minute book because you're required to have them. And I'm going to talk about this here, about piercing the corporate veil in a minute and why it's so important that you have them. Now, the legislature, in their wisdom, if you consider it as such, they don't require annual meetings by the members. But I recommend it, and I think every lawyer should recommend it, and I think you need to populate your minute book for purposes of piercing the corporate veil, and we'll get into that in a couple of minutes. Okay, anybody have any questions about the difference between an LLC and a subchapter S corporation? How are we doing, people on Zoom? How are we doing, South Point?
Good.
All right. Can you guys hear me okay?
Yep.
Yeah, good. All right.
Yeah, very well, Dan.
All right, so taxes. This is very important. Natalia, why didn't you remind me? Come on. I knew there was something that was
imprinted in my mind that I just assume everybody thinks about it all the time.
So when you're a subchapter S corporation, profits have to be distributed proportionate to ownership interest. Remember I said earlier on that sub-S corps are kind of clunky? They have these weird requirements. You're not allowed to have more than 100 shareholders. You're not allowed to have a foreigner as a shareholder. You're not allowed to have certain trusts as a shareholder. And the tax implications is that profits have to be shared proportionate to ownership interest. So if Jake and I go into business and he's 51 and I'm 49, then we have to share the profits 51-49. Or if I say, hey Jake, I'm fronting the money for this, you're going to be the labor, you're going to do the work, I want 90%, you get 10, and we're an S, Jake's going to say, well that's crap, because we have to share profits proportionate to ownership interest, 90-10. Not cool, right? So for those reasons, that's why the legislature created LLCs, because that's not a requirement. If you're an LLC, you can share profits however you agree. Now, this is a pretty cool trick that you have to remember to tell your clients. When you're a sub-S, there's a rule under the Internal Revenue Code that says you can pay yourself reasonable compensation. Reasonable comp. So, Jake is the CEO of our company, and what is reasonable comp for the CEO of, what kind of company did we make, Jake?